You want some local food there? Good morning.
Hey, Mr. Stewart, how are you? Happy Friday.
Happy Friday as well.
You're Robert Ramsey.
Yes, sir.
Mr. Ramsey, you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 14th, 2025, officers observed a 2007 gray Toyota Solara traveling at 100 miles per hour in the 65 miles per hour zone. Officers caught up to the vehicle and conducted a traffic stop and made contact with the defendant, the driver, and observed an open bottle of whiskey in the front passenger area. The defendant admitted to having a few swigs of that whiskey. The officer observed slurred speech, confused demeanor. SFSTs were conducted. It was a 6 out of 6. Walk-in turn, a 6 out of 8. 6 out of 6 on the HDN, 6 out of 8 on the walk-in turn, and 2 out of 4 on the one-leg stand. The defendant consented to breath, which came back to a .199 and a .208.
Did you say field sobriety tests were done or no?
Yes,
Okay, I missed it. So
I'm sorry.
Zoned
SFSTs
out.
were a 6 out of 6 on the HDN, a 6 out of 8 on the walk-in turn, and a 2 out of 4 on the one-leg stand.
got it. Okay, and you said, are you telling me that he's consuming alcohol while driving? Mr. Ramsey, I'm going to find that there's probable cause to go forward with the case. I am now taking away your ability to drive. I'm now making that a condition of your bond. You'll be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in your life. Do you understand?
Yes, sir.
If I find that you drive, I can have a contempt hearing. This is an affidavit that you're going to sign, promising me you're not going to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, Your Honor.
Your Honor, may I at least request an interlock device rather than a no driving affidavit? That would
He's going
guarantee-
100 and he's allegedly taking swigs. What? No. No driving. Do you understand?
Yes, sir.
May I at least make the argument?
Sure.
So he does have to drive to get to work. I understand the accusations against him. I also believe that there's some falsehoods in the accusations against him, Your Honor. We don't have any videos. We don't have any evidence yet on the case other than just the DIMS report here. So, like I said, in reference to the alcohol being, guaranteeing the safety of the community, I would ask that the interlock be installed rather than it being a no driving affidavit. As far as the driving quickly, I'm sure that, he won't drive that quickly anymore, and he will swear that he will not speed or do anything else. We can say if he gets a ticket or something like that for speeding, Your Honor, that then we'd, accede to or agree to the no driving affidavit, Your Honor. But I do think the interlock device would fully guarantee the safety of the public in terms of him not being able to drive and then operate the vehicle.
Ready to be honest?
No, Your Honor.
I'm sorry. I'm taking away your privilege to drive for the moment. I don't care. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol, I will put you in jail. No more PR bonds. Do you understand?
Yes, Your
I would
Honor.
hope that you recognize it's elementary that you're not to have alcohol in the car while you are driving.
Yes, Your Honor.
It's not absolute. But I want you to understand that this is a privilege. It's not a right. You want a right? Take your happy feet and walk from one place to the other. That's a right. This is a privilege. And if you look on the news every single day, someone dies in our county from an intoxication, assault, crash, whatever it may be. No. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance. But it is your responsibility to stay in touch with Mr. Stewart. If he tells me he can't get a hold of you because you're playing games, ducking, dodging phone calls, you pick up a new case, you know what happens.
Yes, sir.
For now, I'm going to have you come up here, store touch it, you're not going to drive. I'll get you to Victoria Center reset. You will get with Felicia for your bond conditions, and after that, you're free to go. All right. It's not absolute. After some time, show me some proactivity, and then we can talk.
All right, thank you, Your Honor.
All right. Yes, sir.
Next is page 8, Lemus.
Good morning, Mr. Payne.
Your Honor.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 15th at approximately 11:22 p.m., the officers were dispatched to a 911 call regarding a three-way motor vehicle crash at the intersection of Spencer Highway and 11th Street in Harris County, Texas. The defendant motor vehicle was identified by his Texas license plate. The officer made contact with the defendant and observed slurred speech, red glassy eyes, and strong odor of alcoholic beverage and poor balance. During the investigation, it was apparent that the defendant's motor vehicle failed to yield the right of way for left turn, causing the defendant's vehicle to strike Unit 2, causing Unit 2 to strike Unit 3. All parties involved advised at the time of the collision the defendant was operating his motor vehicle. The defendant advised that he consumed 3 tall boy Michelob Ultras at a residence prior to operating the motor vehicle. One open container was found cold to the touch and was located on the right outside of the defendant's motor vehicle's driver's side door, and that the defendant was advised that was his 4th beer. SMSTs were conducted. It was a 6 out of 6 on the HGN, a 7 out of 8 on the walk and turn, and a 3 out of 4 on the one-leg stand. The defendant was placed into custody and was transported to the police station. The DIC was read and sentenced to breath, which the results were a .234 and a .230.
Are you telling me that he had alcohol in the car and he's
Yes,
drinking while he's driving as well?
I cannot tell you whether he was drinking while he was driving, but alcohol was found in the vehicle.
Where was it?
It was found in the vehicle on the driver's side door.
Mr. Payne, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising that you're not going to drive. I don't care what's going on in your life. If I find that you drive, I can have a contempt hearing. You could be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, Your Honor.
Judge, may I request? I understand why the court is concerned about this case. Can we just limit it so he can just drive for the certain hours of the day so he can support himself to do the necessary things in his home with the interlock device and/or scram device as well? I mean, it's hard, as you know, in Houston, Texas, it's hard for someone to be able to live where we have without any public transportation or anything to get around. If we can just limit his driving just to the specific hours that the court allows.
How old are you, sir?
21.
He's 21. He has beer in the car and he's a .26.
2-3, I thought, but I mean, I'm not to quibble, but yes.
No,
But
you are not
because of
to
non-conditions just
drive.
being a bit egregious considering it's his first
I
offense.
understand, Herman, and I would recognize, or I would understand that it's elementary that you're not to have alcohol in the car while you're driving. And there's a 3-car collision. He's a .23 with alcohol in the car. No, I don't want you driving. And I'm telling you now, if I find that you do, there's going to be HE double hockey sticks to pay. Do you understand? You're also not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will be spending quite some time with me.
Will you reconsider the order or the condition,
I
Judge?
will always do it. Yes. I want some time to pass
Sure.
and I want to see some proactivity, Herman, and I'm always all ears. But for the moment, I don't want him anywhere near a car.
Is his appearance waived as long as he's maintaining his conditions, Judge?
Because you have a lawyer, I will waive your appearance. So you don't have to waste your time coming to court. But Mr. Payne, I want you to understand that I'm going to do everything in my power to protect my city at all costs. If that means putting you in custody, I don't care. If you have Jesus here arguing on your behalf, I will protect my city at all costs. Do you understand? So, all right, I'll have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria Center Restate. You'll get with the police if you're bond conditions, then you're free to go. Thanks, sir. Is it Gaston or
Gaston.
Gaston? Mr. Gaston, you're charged with 2 cases. You're charged with evading arrest or detention and unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 14th, 2025, an officer observed a vehicle speeding on Gulf Freeway feeder by radar device going 72 miles per hour in a 40-mile-per-hour zone. The officer then observed the vehicle turn left at a red light. A traffic stop was initiated. The officer instructed the driver to step out of the vehicle, and the officer began to detain the driver. As the officer was detaining the driver, the front passenger, the defendant, exited the vehicle. The officer instructed the defendant to return to the vehicle, and the defendant ignored the officer's instructions and started to walk away. The officer ordered the defendant to stop, and the defendant started running northbound. The officer observed the defendant place his left hand near the front of his waistband and throw a small black and blue object near a fence. The officer informed other officers of the defendant's location. Officers observed the defendant running eastbound on the 3,300th block of Scott Street and attempted to apprehend the defendant. The defendant was apprehended at the 3,100th block of Milby Street, approximately 0.2 miles away from the scene. The officers searched the area and located a firearm. The officer remained in visual contact with the location and no individuals approached that area.
What are they doing wrong? I mean, the officer just stops them and just arrests them? What for?
I'm not sure why the officer immediately detained him.
Really? Is that what we do now? We just stop and arrest? No, I'm gonna find no probable cause in your case. Just be careful, man. If you got a gun, God forbid you use it, something happens, you dig yourself in a hole. Come on, man. We got one life. Be smart. Go to school, get some knowledge, make a ton of money, you know? Take a seat, please. Thanks, bud. Did they arrest the driver? I mean, did they charge him with anything? Do you know? Do we have him for anything?
No, there's no,
It was a speeding stop where the passenger was getting out of the car. I would say the officer would have the right to at least make sure the passenger was in the car while he was getting stopped. That's his.
yes.
I don't even think that's an arrestable offense. You know? It's not an arrestable offense. They just literally pull him out, he's speeding and they arrest him. And then the co-defendant's doing nothing wrong. He just gets out of the car. He can just walk away. Yeah, I don't see anything wrong.